Welcome back, guys. Today we're going to talk about the HOA lien foreclosure. It is unlawful because the HOA lien foreclosure code or statute does not contain the necessary elements to be considered a valid law. The missing elements rob the court of jurisdiction, and the HOA lien foreclosure must be dismissed. In this video, I will explain why the court lacks jurisdiction to rule on the HOA lien foreclosure case, and what you need to do about it. This video is to educate you on the options that you have that attorneys do not discuss with people. You will also get a link to the documents you need to challenge the jurisdiction and get control of your HOA lien foreclosure situation. My name is Coach Neighbors, and I'm a paralegal who do not like what attorneys have been doing to people, and I decided to step up and do something about it. I'm going to teach you how to fight back. This video is going to be part of a new playlist on my YouTube channel, and it's going to be titled HOA Lien Foreclosure Defense. So if you're dealing with HOA issues, you're going to want to watch all the videos in this that I'm going to have in this playlist. The problem with the HOA and a third-party debt collection is they use invalid codes and statutes to execute the HOA lien foreclosure. So if this is your first time here and you want to learn how to stop the HOA lien foreclosure process and protect yourself from unlawful statutes and codes, subscribe down below and click the bell because law school is about to be in session. The court lacks jurisdiction to hear the HOA lien foreclosure because of the invalid code or statute. But attorneys and judges move forward anyway because homeowners have no idea. But we're about to change that. The codes and statutes used do not contain the three elements necessary to be considered a valid law. Today, I will show you how to challenge the court's jurisdiction in almost any situation that involves codes or statute. This notice of jurisdiction challenge that I put together will be what you can use. It'll take a little bit of personalizing, but it can be done very easily once you understand what the driving force is behind it. Be clear, the code or statutes third-party debt collectors use to help the HOA steal your property does not have the requirements to be considered a valid. If the law is invalid, you are consenting to be held to that law by not objecting or filing your own suit in a higher court. Okay, so who wants to go through filing in court and going to court, doing all that stuff that you have to do when you file a case? Now you can file one document in their case and blow it up without even answering to their lawsuit. Remember, their notes say, you have so many days and you're going to be in default, and people all freak out over that. They want you to follow those rules that they give you. Fact of the matter is, and you'll find out in this presentation, you can challenge jurisdiction at any time. So the best time to challenge it is right out the gate. You don't have to answer them. Serve them your challenge of jurisdiction and make them answer to you. A challenge of jurisdiction can be raised at any time. It's never time barred, up to 15 years. If the statute and code the attorneys using do not have the three elements needed to be considered a valid law as per the state constitution and the Supreme Court rules, the parties have no standing and the court does not have jurisdiction to hear the case. The case must be dismissed at once to avoid civil liability to the court. This will be the best investment into defending yourself and your property against statutes and codes. Once you learn the missing elements, you will be able to defend yourself and they will not want you in their court. I have been working for years trying to structure a document that will shut down the foreclosure without having to pay filing fees. And my goal was to have just one document. And I think this is going to be the one. Jurisdiction. Proof of jurisdiction must appear on the record. Once the court has knowledge that subject matter is lacking, the court, meaning the judge, has no jurisdiction but to dismiss the action. Failure to dismiss the action means the court is proceeding in clear absence of jurisdiction and subjects the judge to suit. Personal jurisdiction is not usually an issue, but in most proceedings, subject matter jurisdiction is always an issue. Subject matter jurisdiction is not everything, it is the only thing. Subject matter jurisdiction requires a competent witness or notarized affidavit demonstrating an injury and a statutory common law basis for a remedy of injury. So right out the gate, we see that they don't have those two. They never put those two in there. Another important factor that most litigants forget is that attorneys cannot testify as a witness in hearings or in trial. And I'll tell you this one tip. If the judge allows the attorney to testify, what you need to do is object. And after you get done objecting, you make sure you let the judge know that if the judge is going to allow the attorney to testify, you'd like to have the attorney sworn in so you can cross-examine them, because you have a right to cross-examine anybody that's testifying against you. And that would be a problem for the attorneys, because once they're sworn in, they testify, and they become a witness to the case, they become a party to the case, and they can't litigate a case that they're a party to. Any rule that involves the violation of due process or obstruction of administration of justice under the 5th, 6th, and 7th Amendment is also a void judgment. Now, I got a bunch of case laws I'm going to mention the front half of. I'll copy and paste and put those case laws in the comment section down below, so you guys can copy and paste them if you need to use them. Any ruling made by a court which there was a lack of subject matter jurisdiction is called a void judgment. The real issue in void judgment is subject matter jurisdiction, or a lack thereof. Subject matter jurisdiction can never be presumed, never be waived, and cannot be construed even by mutual consent of all parties. Subject matter jurisdiction defects include the following. And I won't go over all of these. I'm just going to go over a few of them, but I will leave all of them in the comment section down below because there's quite a few of them. So petition in the record of a case, defective petition filed, Brown versus Van Keur, fraud committed in the procurement of jurisdiction, Fredman Brothers Furniture versus Department of Revenue, fraud upon the court, Village versus Willowbrook, the judge does not follow statutory procedures, Armstrong versus Aquino, unlawful activity of a judge, Code of Judicial Conduct, a violation of due process, if the court exceeds its statutory authority, any acts in violation of 11 U.S.C. section 362A. A void judgment can be attacked or vacated at any time. There is no statute of limitations. See Long versus Shorebank Development Corporation. A void judgment is one which from its inception was incomplete nullity without legal effect. Lubin versus Selective Service Systems Local. Open up my share window and show you guys just the front page of the document so you can see that it's real. Okay, this is challenge your jurisdiction with affidavit. Now, you guys will have to replace the red font with your information. And there's not a lot of information that you need to put in here. And there's a few places where you have to put your name a whole bunch of times. So you replace your name where it says John Allen Doe. And I just want to show you a couple of pages. Okay, my solution to this problem is to file your challenge to the court's jurisdiction in the very beginning or any time to blow up their case, because the codes and statutes are not valid laws. Once you get their case dismissed, it will be a cakewalk for you to file your wrongful foreclosure lawsuit, and you will add file stamp copies of the dismissal to your claim as exhibits. If the HOA is attacking your property, or if they already attacked your property, it's not too late to take control and hold them accountable. Head over to my website at winincourtnow.com and get the HOA foreclosure lawsuit package that's on sale right now for an unbelievably low price of $200, and get control of your HOA foreclosure situation today. In our next video, we're going to show you our new document that we posted in our debt collection playlist, and give you a little information about how you need to be protecting yourself if you got debt collectors up in your face. So I know this coronavirus mess has hurt a lot of people's income, and I know the debt collectors are just waiting. So we're going to be putting some things out there that's going to help you guys out. You guys want to stay tuned, and don't forget, subscribe down below, click that bell so you don't miss anything when class starts, and let's get rolling.